Okay, so we talked about if you have certain amount of assets, then you need to have a living trust. But there's a couple other conditions that you might need one or want one. One is making medical decisions, and that can be a whole variety of circumstances. I had one where an elderly aunt who was living with but not married to, I call him my uncle, but he's not really legally, and he had medical issues. He had some medical insurance that should have covered those issues. He could. He was in the hospital. She went to find the insurance company. She couldn't find the bill, so she went to call the bank. But of course, she doesn't have access to the account because it's in his name, not her name. But if you have directives and such when people are incapacitated, you have the right to do that, and that's ordinarily part of an estate plan, isn't it? The medical kind of procedural authorities, things like that.
Absolutely. So we have what we generally refer to as ancillary estate planning documents. So the entire comprehensive estate plan is comprised of a multitude of documents, commonly the trust and the backup will you mentioned earlier, power of attorney we just hit on, now the advanced healthcare directive, the medical directive, the living will, common terms and colloquial exchanges with people will identify that these documents independently predetermine medical decisions that each person gets to elect on their own. And then they have agents to effectuate them should the time arrive that they're incapable of expressing themselves or making these determinations voluntarily. Imperative that we have that. Everybody needs a medical directive as well as all the other documents.